You guys ready? We're going. We're moving. Good morning, everyone. We've got a packed agenda today. Before we get started, I'm going to ask the clerk to take attendance.
Chair Breen.
Present.
Representatives Edwards.
Present.
Carter.
Present.
Hope. Here. Arbet.
Here.
Devendorf. Here. Hoskins.
Here.
Cerniglu. Here. Fink.
Here.
Wenzel. Here. Wozniak.
Here.
Outman.
Here.
Johnson. Here. Madam Chair, you have 13 members present. You do have a quorum.
Thank you, and I will now take a motion from Representative Edwards to approve and adopt the minutes from the previous meeting. And those are now adopted. Today, we are going to be wrapping up some testimony on fertility fraud, which is House Bills 4178 through 4182. We're going to hopefully be voting those out as well. We're going to also take testimony on a treatment court package, which is House Bills 4522 through 4525. And we are also taking up the child marriage package, which are House Bills 4293 to 4302. And we will have, we hopefully will have time for people who want to testify. Hopefully we'll get everybody in. If you are not scheduled to speak, we may have to come back later, but we'll see what we can get done. We are going to start, however, with Representative Hope, who's going to give us an update on some substitutes that we have for the child marriage package.
Good morning. So as a result of some of the questions that were raised, some of the concerns that were raised at our last hearing, as well as some concerns raised by Minority Vice Chair Fink, we have a number of substitutes and one amendment. And I'm happy to go through those right now. Okay. So for 4293, that's HB 4293, we have a substitute that simply clarifies that this is not retroactive. So if you were married as a minor, you will still be married as a minor. If your marriage will still be valid in the event that this passes and becomes law. 4294 is merely fixing a typo regarding the tie bar to make sure that that's accurate. There's an amendment to 4296 that clarifies that minors who are legally married in other states and subsequently move to Michigan, if this bill is law, they will not be subject to parental control. And that was a concern raised by Rep. Fink. So we're not sort of binding a person who was married as a minor in another state to their parents if they move here. They're also not going to be subject to parental control. And feel free to stop me with questions at any time. 4301, that one has a sub and an amendment.
Representative Hope, Representative Fink has a question.
Oh, I'm sorry.
I just wanted to kind of clarify. I guess I'll state it as a statement and ask you if you agree with it. But when we say under whichever bill it was that you just mentioned about parental control, 4296, when we say that, as I understand it, what we won't be doing is creating sort of a dual status where we have a legally recognized marriage that, according to one of the other subs, will probably, at least in almost every case, emancipate such a minor, and then also say, but the minor is still subject to parental control and has to go to whatever school her parents decide or whatever. We're eliminating that kind of concern about on the one sense saying, okay, you're married and you're out, and on the other hand saying your parents are still your boss even though you're married or whatever.
That's correct.
Okay,
That's,
thank you.
That's exactly right. Let's see. Okay, 4301, that one has a substitute, and then the substitute's amended. Basically what it does is sort of in the same vein, if you're emancipated in another state and you happen to be married, you will be emancipated if you're emancipated in the other state. Sounds like doublespeak, but you'd be emancipated here. Okay, I knew I had that wrong. Is everybody confused now? Sorry. So basically, it's the same thing as the one that we were just talking about. If you're emancipated in another state, you're emancipated here. Just wanted to make that clear. And then 4302 had an unfortunate, I won't call it a typo, but it was a major problem. That makes it clear now that we're not legalizing enticing minors to come to Michigan and get married. Small thing. So those are the changes. I hope they're clear. The language doesn't change a lot, but the impact, I think, is there. Making it clear that we're not going to, if you happen to be married in another state and you come to Michigan as a minor, we're not going to make life worse for you. That's a really simple way to put it.
Does anybody have questions for Representative Hope? Wait. Oh, I'm sorry, Representative Johnson, you have a question?
Just for clarification, and these are improvements, I appreciate it. But we still have no penalty outlined. And we still will have on the books that the age of sexual consent, statutory rape is 16, correct? Even though this is 18, correct?
This is just for marriage.
Yeah, Representative Johnson, this is the civil arena, so criminal penalty would have to be addressed in a different way if that were to happen. And
Right.
again,
I just want to clarify that that is the situation.
happy to have these ongoing conversations.
Yep,
Thank you.
The criminal law will be unchanged. This is simply changing the standards for marriage.
Okay. If we don't have any questions, just so the audience is aware, I'm going to read in some cards. We have one person wishing to give what I hope will be a very brief testimony. We're going to take a 60-second pause and then start voting on these. Okay. Supporting the package of bills, not wishing to speak, Mitch Elbers from the Department of the Attorney General. Supporting bills 4293 to 4302, Stephanie Johnson on behalf of the Family Law Section of the State Bar. Jess Averill on behalf of the Michigan Domestic and Sexual Violence Prevention and Treatment Board, supporting bills 4293, 4294, 4295, neutral on 4301. And supporting House Bill 4298, Sharday Burton from the Michigan Department of Health and Human Services. Supporting the package, Mr. Austin Kreutz. Okay, I apologize. And sir, you wish to speak? Yeah. Okay, could you please limit your testimony to 2 to 3 minutes? Sure. Okay.
Thank you for the opportunity to address these bills. I'm supporting the bill. The thing as a pastor that I see a lot is people being pressured into marriage, people being asked or not even asked. My main concern with this and support of it is that there are people in our state that are looking at trying to push the concept and idea of child marriage as young as sometimes the age of 9, 12, etc. I support these bills because I believe that a child does not have the ability or ethical ability, moral ability to make that decision, particularly when The cerebral cortex of an individual does not mature until about age 25. So I would say that these bills are good. I would say that we need to support them, and I would say that also I would ask if, for consideration, that there would be some type of protection for ministers who are found trapped in this situation, who are refusing to do the marriage. So these are things that I think important. I think it's kind of ironic that we recognize that 18 and below cannot make a moral decision for a life partner, but we've given them the ability to have an abortion without question or sex change. Thank you very much for the opportunity to speak. God bless.
The committee will very briefly go at ease. We are back, everyone, and we are now going to start voting this package out. Please be patient as we have substitutes for several of these. I have an H1 sub for House Bill 4293. I will take a motion from Representative Edwards to adopt the sub. Madam Clerk, please call the roll.
To adopt the substitute H1 to House Bill 4293, Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arvid.
Yes.
Stevendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Altman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 passed. The substitute is adopted.
Thank you. I will now take a motion from Representative Carter to report House Bill 4293 as sub H1 with recommendation. Madam Clerk, please call the roll.
Chair Breen.
Aye.
Representatives Edwards. Yes. Carter.
Yes.
Pope.
Yes.
Arvid.
Yes.
Stevendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Altman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 passed. House Bill 4293 is reported with recommendation of substitute H1.
We have an H1 substitute for House Bill 4294. I have a motion from Representative Hope to adopt the sub. Madam Clerk, please call the roll.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arvid.
Yes.
Stevendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. Substitute is adopted.
Thank you. I will now take a motion from Representative Arbit to report House Bill 4294 as sub H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards. Yes. Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Stevendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4294 is reported with recommendation to substitute H1.
Thank you. We now have House Bill 4295 as it is, and I will take a motion from Representative Devendorf to report House Bill 4295 with recommendation.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4295 is reported with recommendation.
Thank you. We now have a substitute H1 for House Bill 4296. Representative Hoskins makes the motion to adopt the H1 sub. Madam Clerk, please call the roll.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. Substitute is adopted.
I will now take a motion from Representative Sergaloo to report House Bill 4296 as sub H1 with recommendation. Madam Clerk, please call the roll.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4296 is reported with recommendation as substitute H1.
Thank you. I will now take a motion from Representative Edwards to report House Bill 4297 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4297 is reported with recommendation.
Thank you. I will now take a motion from Representative Tyrone Carter to report House Bill 4298 with recommendation. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4298 is reported with recommendation.
Thank you. I will now take a motion from Representative Hope to report House Bill 4299 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4299 is reported with recommendation.
Thank you. I will now take a motion from Representative Arbit to report House Bill 4300 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4300 is reported with recommendation.
Thank you. I have a H1 substitute for House Bill 4301. Representative Devendorf makes the motion to adopt the sub. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arvet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. The substitute is adopted.
I have an amendment to House Bill 4301 H1 from Representative Hope. Do you wish to speak to your amendment?
No, I think what I already said is sufficient. Thank you.
Thank you. I have a motion from Representative Hope to adopt the amendment. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arvet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. The amendment is adopted.
Thank you, Madam Clerk. I will now take a motion from Representative Hoskins to report the bill as amended to the floor as a new sub. Madam Clerk, please call the vote.
To report House Bill 4301 with recommendation as amended as a new sub. Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arvet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4301 is reported with recommendation as amended as a new sub.
Thank you. I have an H1 substitute for House Bill 4302. I will take a motion from Representative Sergilou to adopt the sub. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arvet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. The substitute is adopted.
Thank you. And the last vote we have on this package, I have a motion from Representative Edwards to report House Bill 4302 as sub H1 with recommendation. Madam Clerk, please call the vote.
Chair Breed.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arvet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4302 is reported with recommendation as substitute H1.
Thank you very much. We are now moving on to the fertility fraud bills. Representative Roth, would you care to give us a brief update and introduce our witnesses?
Thank you, Chair Breen and members of the Judiciary. Appreciate you guys listening to me. Just want to reiterate what we talked about last week, the fun that we talked about, we're going to talk more about today. The reason we're doing this again is for some civil liability help for the victims here. Also, want to make sure the donors are acting the best way possible, and that we also have doctors that are doing the most egregious also seek penalties criminally. So it's a big package, but we want to make sure that we cover all of it. We're really putting the guardrails on this business that has none today. So that's our purpose in doing this. Our first witness is Lynn Spencer, and she's going to talk about the importance of also holding donors, not just the doctors and the clinics, but the donors responsible for not telling the truth also. So Lynn, thank you.
Okay, good morning. Can everybody hear me okay?
Yes, thank you for joining us. We're going to ask that you try to limit your testimony to about 2 to 3 minutes.
Okay, well, thank you. So my name is Lynn Spencer, and I want to thank the sponsoring representatives for your perseverance in working on making fertility fraud or fertility treatment more ethical for all involved, the parents, those born through fertility procedures, and the donors. And thank you to the committee for allowing me to share my life experience as a sperm donor offspring. While growing up, my parents told my sister and I that they had trouble getting pregnant and went to a fertility specialist in Detroit for help. But I had no idea there was a sperm donor involved in the process. My dad died 30 years ago, and within days of that, my mother told my sister and I that they had used a sperm donor. Initially, I felt a great sense of relief because so many things made sense all of a sudden. Over time, though, depression set in, confusion, anger at the lies, a burning need to figure out who my biological father was, and wondering if I had any other siblings. I was one of those people who had to know the truth. After 20 years of searching, I did figure out who our donor was. Our donor had his own 4 sons and then donated sperm for 30 years in the Detroit area with Dr. Trithal as his colleagues. Our sibling donor group was born between 1955 and 1984. And as of today, through the DNA sites, we are aware of 74 half siblings, and that number will keep growing as more people do DNA tests. Some of our siblings knew each other before knowing they were siblings. One can only imagine how many siblings we really have. There are so many issues due to not knowing our true identity growing up. The lack of accurate family medical history for our own health care, the effects on family relationships due to secrets being withheld, and not being able to trust the people we should be able to trust the most, our parents. Due to the secrecy surrounding donor conception, what if two half siblings fell in love, married, and had children together, not knowing they were siblings? It is overwhelming having so many siblings, nieces, and nephews. I had to make a spreadsheet to keep track of who my brothers and sisters are. Each time someone new appears on the DNA sites, we have to support them through the process of finding out this new information about themselves and that they are now part of a large tribe of people who are all related. In our donor's family, there's a history of substance abuse, depression, and suicide, and who knows what else. Amongst our siblings, there are some who experience these issues as well. It's important to have accurate family medical history so treatment can start earlier. Let's see, I've heard stories of many donor conceived people, and secrecy and lying is rampant in the industry. There was fertility fraud in our situation too. The doctor told our parents that the donor was a medical student. In fact, he had a 9th-grade education and GED. Our parents were told that the donor would be used for 6 to 8 families. So far, there are 66 families that we are aware of who used his sperm. The donor lied to our parents and misrepresented his educational status and how many families the donor would be used for. In order for ethical donor conception practices to occur, there has to be safeguards for honest information to be provided to people seeking fertility treatment. They need to know that the medical and educational information they are being told is accurate. They need to know that they are getting the gametes, the egg and sperm of the people that they agreed to receive. They need to know how many times their donor is used. They need accurate information about their genetic family medical history. They need to have the ability to find out who their genetic father and family is. People intentionally conceived using donor gametes have a right to know their identity. Parents receiving donor gametes have a right to accurate information about the donor and his or her characteristics. Donors
Ms.
have a
Spencer?
right to know how their gametes are used
Ms.
and
Spencer,
how many.
I really appreciate everything that you're saying. It's incredibly helpful, but could you please wrap it up?
Yes, I actually am. So thank you for considering this legislation to help prevent further fertility fraud. Thank you.
Thank you so, so much. It was very helpful. We also have Kara Rubenstein Dyerin also giving testimony via Zoom. Kara, are you with us?
I am. Hi. Good
Thank
morning.
you. Hi, appreciate your testimony. I remember you from last year, and in the interest of time, please keep your testimony to 2 to 3 minutes.
I will. Thank you so much.
Thank you.
My name's Cara Rubenstein Dayarin. I co-founded and manage a nonprofit organization called Right to Know. We help people impacted by misattributed parentage, like Jamie, who you heard from last week, and Lynn, as well as parents. We have a hotline, so we get phone calls. So we hear about these stories all the time. I just want to take my 2 minutes to put this into perspective for you all, because I think a lot of people are really shocked and surprised. We have very minimal federal regulation in the fertility industry. This is a $41 billion industry globally. The only federal regulation applied to this sector is STI testing and screening for communicable diseases. That means that they're not required to genetically test gametes. There's no requirement to verify donor information like medical, education, or background information. The sad reality is animal husbandry in the United States has far more regulation. This is a self-policed industry and they're doing a poor job. So we need to, as Representative Roth said, set some guardrails here to ensure that there is honesty and integrity when we create human beings. Donors are lying, clinics are making false promises, doctors are using their own sperm. You know, the only way that we know when we request donor 567 that we got that donor is later if we use over-the-counter DNA testing. Donors are lying, as Lynn said, about their background information, their medical history. Clinics are making promises to donors that they're not honoring. There's a number of cases across the United States regarding this. And, you know, husbands and wives are going in and using assisted reproduction services. And then the clinics are promising to dispose of the remaining specimen of the husband. And lo and behold, later on, they're finding offspring from that specimen. So we need consequences for this bad behavior. Because parents, when they are suffering from infertility, they are in a traumatic state of mind and they need help to ensure that they're getting proper information from the clinics and the donors. I'm often asked why there aren't more lawsuits about this. And that's because people like Lynn, the offspring of fertility fraud, don't have standing in the courts. They weren't alive at the time of the harm. They weren't a party to the contract. So all cases that have been brought by offspring across the United States have been dismissed. So why aren't moms bringing these cases more? Well, we all know, you know, going to court is difficult and there is not a clear path to justice, which is why these bills are super important. Moms end up signing non-disclosure agreements and settling, which is sort of creating a Me Too problem and masking the scope of the problem. So when the next person comes forward, they don't know what's happened before. We need to provide Michigan families with a clear path to justice who have suffered from this. I'm happy to answer any questions anyone might have, but let's make consequences for bad acts when we're making a human.
Thank you so much, Cara. We do have a question. Representative Fink?
Thanks, Madam Chair. Thanks, Representative Roth, for being here again and presenting this legislation, which I understand arose in your mind from a constituent, which is a good way of doing our business, listening to our constituents. I think my question is probably best asked of Ms. Rubenstein or Steen. I'm sorry, I missed how you said it. Rubenstein?
Yeah.
Yeah, Dairin? Dairin? I'm sorry, I'm trying to get your name right. I should have just moved on. So my question is, I mean, I recognize that this legislation is an attempt to use the means that we have to remedy a situation that's really never going to be made whole. Right? I mean, the kind of emotional harms that are at stake here, we're approximating it, we're doing our best. Do you think that the frequency of this occasion, of the occasion that's bringing this legislation forward, do you think that that's decreased over the years? In other words, do you think that like as these clinics are they doing any better now than they were like mid-century when some of these cases we've heard about today and last week arose?
I will say that I think doctors are not using their sperm as much as in the past because now they have access to frozen sperm, whereas before they didn't, and women were ready to be inseminated at a specific time. A donor couldn't come in. Plus, doctors are aware that there's over-the-counter DNA testing, but we always have bad apples. We have laws against rape and murder, and people still do that. So we do need consequences for a bad apple doctor who might use their own sperm because they need to quickly, or there's some sexual deviation with that. But I still get calls. I just had a call not that long ago about a woman whose children were in their teens, whose eggs were switched. They didn't get the egg donor that they requested. So a woman just gave birth. Here's an example. She gave birth last year. She used an egg and a sperm donor, carried 2 twins. She was promised that there were no other offspring from the sperm. One of the twins died within 3 months, and when she started investigating, more than 20 children were created from that sperm, and one other baby had died under similar circumstances. So no, I don't think things have improved that much.
Thank you.
And it's just one time too many, right? This poor woman is suffering. If she had access to information, accurate information, then because she was told there was no medical problems with the sperm. And like I said, no other offspring. So there needs to be consequences.
That's helpful. Thank you.
Thank you. We have supporting the package, not wishing to speak, Mitch Elbers from the Department of the Attorney General. We are now going to take up the votes for the fertility fraud package. I have a motion from Representative Edwards to report House Bill 4178 with recommendation. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbit.
Yes.
Demendorf. Yes. Hoskins.
Yes.
Cerniglu. Yes. Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yeah.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4178 is reported with recommendation.
Thank you. I will now take a motion from Representative Tyrone Carter to report House Bill 4179. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbit.
Yes.
Demendorf. Yes. Hoskins.
Yes.
Cerniglu. Yes. Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yeah.
Outman.
Yes.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4179 is reported with recommendation.
Thank you. I will now take a motion from Representative Hope to report House Bill 4180 with recommendation. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards. Carter.
Yes.
Pope.
Yes.
Arbit.
Yes.
Demendorf. Yes. Hoskins.
Yes.
Cerniglu. Yes. Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yeah.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4180 is reported with recommendation.
Thank you. And I'll take a motion from Representative Arbit to report House Bill 4181 with recommendation. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbit.
Yes.
Demendorf. Yes. Hoskins.
Yes.
Cerniglu. Yes. Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yeah.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4181 is reported with recommendation.
Thank you. I will now take a motion from Representative Devendorf to report House Bill 4182 with recommendation. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Carpet.
Yes.
Devendorf. Yes. Hoskins.
Yes.
Cerniglia.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Weisman.
Yes.
Halpern.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4182 is reported with recommendation.
Thank you so much. We are now going to have testimony on the treatment court package, and the committee will go at ease.
Oh, thank you very much. We will have testimony from Rep. Hope, Chair Breen, Rep. Filler, and Kate from the Michigan Association of Treatment Court Professionals.
Thank you very much, Madam Chair. We are here to discuss a wonderful package of bills regarding treatment courts. As many of you are familiar, this is a highly effective therapeutic justice model. Treatment courts focus on providing treatment for underlying issues that lead to crime. And the underlying issues almost always being substance abuse or mental health. It provides intense supervision as well as resources for the people that are before them. Treatment courts reduce crime, they make communities safer, they save a ton of money on incarceration. In a nutshell, they help people to help themselves. My particular bill is regarding the creation of a family court in statute. And the reason why this is necessary is that they are currently operating under the drug treatment court statute, and the drug court statute that targets criminal offenders with underlying substance abuse disorders. And these family treatment courts are intended to be used in civil child abuse and or civil child neglect cases, and will be placed within the family division of circuit court, which operates very, very differently than criminal court. The different components that are needed to help a family treatment court function well are not within the drug court statute, and that is what my bill will rectify. It focuses more on issues like parenting time, parent and child relationships, and what parents will need in order to provide for themselves and their families. We have my colleagues are up here, as well as Kate from the Michigan Association of Treatment Court Professionals, who's going to be able to give a bit more background. But I would like to hand it over to Rep. Filler and then Rep. Hope.
Thank you so much. So I do think really basically that we need to talk. The reason I'm up here is because treatment courts are awesome, and they're money savers for the taxpayer. They have a track record of success. There's treatment courts in my district, and individuals who make it through have incredibly low recidivism rates, and we've kept them away from further taxpayer spending and jail or prison sometimes. My bill is a simple one, and that just says the bill would allow a judge or prosecutor in consultation with any known victims to waive a person who's committed certain crimes into treatment court. Currently, there's a complete prohibition on anyone who has committed an assaultive crime from being enrolled into a specialty or treatment court. And this bill would simply amend the statute to say that an individual could be allowed into treatment court if the judge and prosecutor, with input of the victim, agreed to waive the prohibition. So we took testimony on these bills last term in Judiciary. People seem to think, Michigan Association of Treatment Court Professionals and judges and prosecutors, that this is a pretty rare situation, but that there are situations where everyone involved in the process agrees that this individual will really benefit from treatment court. And so this is just a very small change, and I do ask for your support. Thank you.
Thank you. I'll echo Rep. Filler's sentiments that treatment courts are awesome. I was a county commissioner, and I, in that capacity, had the pleasure of attending many graduations from Ingham County's sobriety court. And, you know, it's a better investment of taxpayer dollars and better results, not just for the individual and their families, but for the community. My bill would allow violent offenders to participate in mental health court. And you can imagine, you know, the underlying offense, the violent behavior, may be an outgrowth of the mental issues. So it makes sense to allow them to remain there where they're going to get treated. And then I'm also speaking to Representative Andrews' Bill 4524, which allows participants to remain in a drug treatment court program if they've committed a felony after being admitted to the program. Currently, they're not allowed to do that. This would give the judge the discretion to allow them to remain in the program.
Thank you, committee, for having me here. And again, our greatest appreciation to Representative Breen, Filler, Hope, and Andrews for reintroducing our 3-bill package along with the family treatment court. You've heard the basics of what these bills would do. I know that we have 2 judges who are going to speak more to that, so I would rather the time be spent listening to them, but I will be available for questions afterwards. Thank you.
Before we welcome Judge Reeds, I'd just like to say that I'm very excited to see him as he is a judge in my hometown of Novi.
Before we go to the individuals on Zoom, we have a question from Representative Fink, and I do have to ask you to keep it quick.
You want me to save it for after they testify?
If you feel. Thank you. So we have testimony from Judge Sue, which is on Zoom, and Judge Travis Reeds.
Who would like to go first? Judge Dobrich, you want to go first?
We can have Judge Sue go first, please. Judge Dobrich, could you please go ahead? Can you hear us? Hello? Okay, well then we're gonna have Judge Travis Reed go first, please. We can't hear you either.
Good morning, everyone. Can you hear me?
Yes, we can hear you now. Thank you.
Thank you all for having me come and testify. I give a shout out to Representative Breen, who is from our district and does a lot of great work in our district. So thank you for having me. I was approached by the MATCAP program to come and testify to you today. I apologize. I'm still at work. We have some cases left to do, but I wanted to take a break to come and testify at the hearing today about these bills because I think they provide a real benefit to those of us who participate in treatment courts. And in the 52nd District Court, we are very privileged to have 4 different treatment courts. we have a sobriety court, which focuses on recidivist drunk driving offenders. We have a drug court, which focuses on a variety of different types of potential crimes that may come through the court, but with a focus on people who, instead of alcohol as their primary substance of abuse, have some other form of substance that they abuse or are addicted to. We have a mental health treatment court, and we have a veterans treatment court. All of these courts have similar goals, but different models, different structures, but they are all very successful programs for the participants, and I think for the community as well. I would echo one of the previous comments. This is a fantastic use of resources. The traditional model for sentencing does not work as well with people with substance abuse issues, severe substance abuse issues, or mental health issues as the treatment court models. And giving the judges discretion in the rare circumstances where these issues like a felony conviction or a violent offense as a predicate arise, giving the judge discretion in those circumstances is just going to provide an additional community benefit. And it is fairly rare. I will say that in my experience and actively working on these programs for about the last 8 years, we may have had 1 or 2 people where we would have wanted them to come into the program with a violent offense. And just as a small correction, the actual statutory definition in the current law is not any violent offense is precluded. The current statutory preclusion is if there is death or serious bodily injury. And so there are a variety of quote unquote assaultive crimes where that label is attached, where there is no death or serious bodily injury, and those people could come into the program. An example might be a felonious assault case where there's a weapon involved, let's say a knife. We had a case similar to this in our mental health court, and the person got charged with felonious assault because they held the knife. No one got touched with the knife. No one got injured with the knife. And it was clearly a result of, a severe acute manic mental health episode. And that person, and let's face it, especially with that population of people that we're trying to help, you're going to have violent outbursts in the mental health arena. And if no one is hurt, and there's the discretion for the judge to keep that person in the program and or bring them into the program, that benefit to the community and to any potential victims and to the participant is incalculable. And this is a minor change, but I think it is significant. This is not going to let everyone into these programs. I just want to assure everyone that there's a screening process. It requires prosecutorial agreement. So there's yet another check and balance. If there's a case where there's a victim, the victim would also have to be brought into the decision loop. And so there's a lot of balance to it, but it also gives us the opportunity to at least talk about it in our team meetings. And, obviously, are we going to take someone who gets charged with murder into our program? No, we're not going to do that. On the other hand, the example of the felonious assault or even something that has nothing to do with assault or violence in any way, let's say a bad check case or a joyriding case, something like that, a property crime, albeit a felony, may well not preclude someone if we had the discretion because we're getting such a benefit. And we have turned a couple people away because we were unable to take them in. And I think that was a missed opportunity. I really do. And just as a side note, I want to mention that even though I'm not here today on behalf of the District Judges Association, I am on the executive board of the District Judges Association. And last session, we did drop a card in support of these bills when they were brought up at the last session. And I would also just extend an invitation to any or all of you, if you would like to come and see a graduation. We just had the privilege of having our newest Justice Bolden come to our last graduation. It was a real honor to have her there. But it's a very uplifting experience, and you could see firsthand if you came to one of these graduations, what an incredible impact the program can have on not only the community, but the participants. I believe that's all I had for today, unless there are any questions.
No, thank you very much. Judge Sue, you want me? Pink, are you ready?
Yeah, I'll wait till the end.
Okay. Judge Dober, can you hear us now? Hello, can you hear us now? Okay, we're going to go ahead and take a question from Representative Fink.
Yeah, my question does relate, thank you.
Good morning, everyone. Can you hear me?
I'm going to.
Okay, We can hear you now. Go ahead.
Matt, can you hear me?
We
Thank
can.
you for giving us this opportunity. Okay, it says yes, go ahead. I'm sorry, I can't tell if you can hear me or not. Thank you for giving me this opportunity to talk about family treatment courts. Is something near and dear to me. And I want to introduce myself. My name is Sue Dobrich, and I'm a retired probate judge. I served in the family division as well as probate from 1995 to 2001, where I retired. And currently, I'm a visiting judge in jurisdictions such as Kent County, and also am consulting. I had the first family treatment court in Michigan. I'm a current member of MADCAP and a former president of MADCAP. I had an opportunity to review your legislative analysis, and so I'll keep my remarks short because the legislative analysis was well written and covered family treatment courts very well. What I want to talk mostly about is that family treatment courts are part of the family court docket, and they target civil cases, not criminal cases, of child abuse and neglect in which parental substance addiction is a contributing factor. Statistically, we know that over 80% of the cases nationwide of kids who are in foster care as a result of addiction. And this is one method of working with families to hopefully reunite children in a safe, nurturing, and sober environment. A family treatment court is similar to all the other treatment courts, and it's done by a team of judges, attorneys, child protective staff, and treatment personnel, and the Department of Health and Human Services, with the goal of not only ensuring that there is a safe home for children, but at the same time working with the parents or guardians to help stabilize and provide lifetime recovery so that children can be safely reunited within the federal timeframes. We currently operate under the criminal drug court statute. As I indicated, this statute was written for criminal offenders with a SUD, unlike the civil family cases with SUD. As a result, family issues cover many more aspects than a criminal case and have many more participants, including the children as well as all the parents. Additionally, because problem-solving courts are required to be certified, which really is essential to ensure that the courts are being properly operated, the certification legislation does not apply to family treatment court cases because they leave out major stakeholders, including the Department of Health and Human Services and the guardian ad litem. Most importantly, the current drug statute does not address the key components of a family case, which includes the relationship of parent and child, education, parenting time, family-centered treatment. And the new FTC legislation as proposed would encompass these guidelines. The guidelines are written up in a federal handout, which is called Family Treatment Court Best Practices Standards, which set out standards that was published by the National Association of Drug Court Professionals, as well as Family Futures. This new legislation would provide that blueprint and ensure these standards and best practices design are being met by your family treatment courts in Michigan. Previously, there had been some questions, I think, in last year about creating a new court. Family treatment courts are not a new court. They've been long established, but because they are labor intensive, there's less of the family treatment courts in Michigan than there are other types of drug courts. The civil statute would allow us to include all the parameters that are necessary in family treatment courts, and I think your legislative analysis really addresses that. Um, I'm prepared to answer any questions that you have now or in the future, and you can always contact me at any time to discuss this. As I indicated, it's a real passion because this really provides a treatment plan for families, and it addresses the primary issue of why children are in foster care, and that is addiction. As I indicated, 80% of all children in foster care, they can establish these numbers, are as a result of addiction. And you know very well from all the other areas that you're working on how serious this problem is. And treatment really works, and family treatment courts are highly effective to assist our families. And thank you.
Thank you very much. We do have one question from Representative Fink.
Thanks, Madam Vice Chair. This is a kind of a hybrid question, a general one, and then a more specific one. My understanding is, and I think somebody testified this morning, that there is, in the long run, saving resources if we have effective treatment courts. And I think we talked about that when you testified earlier this term about the concept of treatment courts. But as I understand it, with regard to these violent offenders, the reason that they probably haven't been involved is because in the moment, a treatment court case is more resource intensive, more time intensive for the judge, prosecutor, the rest of the team. You know, you go to one of these treatment court graduations, and it's like a dozen people who are involved in kind of keeping the whole thing going. And so, given that I think at some point we're going to hear about trial court funding and whether there are adequate resources at the trial court level today, do you have any concerns about that? And then the secondary concern I guess I have is why were violent offenders excluded in the first place? You know, and has something changed since then that makes it make sense to bring them in now?
As to trial court funding, yes, that is absolutely something that we do need to address. I'm hoping to do that over the summer. I'm happy to work with you on it. Also, Representative Wilson, who chairs the subcommittee for appropriations, Judiciary, because it's going to be a heavy lift, and we need to make sure that our trial courts are funded. These do take a lot of resources, but it does also save money. And as to the second part as to why violent offenders are excluded, I'm going to let Kate take that away.
Yes, thank you for that question, Representative Fink. I wish that Judge Harvey Hoffman, who is our MATCP legislative director, was here, but he is in the Great Smoky Mountains right now enjoying a vacation with his wife, Sue. But if Judge Hoffman was here, I'm going to try and channel him. He would probably say when he was writing the initial drug treatment court statutes over 20 years ago, we just wanted to get it done. These were kind of new programs. The first treatment court came out of upstate New York, and there was a lot of hesitation. People weren't sure, you know, these newfangled programs, if they were going to work. But now we have the data. We have the data to show that treatment courts do work. Recidivism rates are better in treatment courts. We have successful people employed, getting educated, roofs over their heads, reuniting with families. We have also made great strides in just better understanding substance use disorder and mental health over the past couple decades. And so the question of why now is because we have all come a long way. Even in the few years that I've been working with MATCP, I have seen a great change in our treatment courts and being more accepting of things like medication for opioid use disorder, understanding the science behind brain development and how brains are affected by substance use disorder. So I think we just have better data and better understanding of and better compassion for why we should allow individuals to maybe if they had something happen, 10 years ago, and now they're before the court on a DWI, why we should allow them in. I hope that answers your question a little bit.
But one of these changes would be like if a crime is committed during the pendency of the instant case, right? So I mean, that wouldn't be like a look back. That would actually be, I mean, in my understanding, that would be a pretty big change from how we're doing it now.
So you're talking about for the new felonies?
Yes.
Yes. So if I can actually just share some statistics with you, yes, it would be a change. But these came from Judge Phyllis McMillan, who runs the adult drug courts, which is at the circuit court level in Oakland County. And she provides us with information since the beginning of their program. They have had 1,098 participants. Only 54 were discharged from the program due to new felonies. So we're talking about very small numbers here. And again, I think we keep going back to discretion. So maybe somebody is in the very initial stages of a treatment court program, and they did pick up uttering and publishing, or writing a bad check, felony charge. If they've committed to the program, they had some sort of lapse in judgment, we allow for reoccurrences in treatment courts. We're not letting people go when they relapse due to their substance use disorder. We should allow our judges and prosecutors that discretion to say, yep, this occurred really early on. It's something that is a result of your substance use disorder. You've already committed to the program. We're seeing some progress. We don't want to have to discharge you now because of this. But we're talking about probably very small percentages of the cases. We just want the discretion to keep those small numbers, have the ability to perhaps keep them in. And doesn't mean that everyone who picks up a new felony is going to be kept in. I'm sure there will be plenty of times where the judge and the prosecutor and the team decide, no, this was too serious and they really do need to be terminated.
Just to piggyback on that, just because it's a felony, that doesn't necessarily mean it's a violent felony. And also, for any violent offenses, it also includes consultation with the victim.
We have one more last quick question from Representative Wozniak.
Thank you, Madam Chair. I would imagine since the participation in this type of court is almost all voluntary, do the participants represent themselves or did they get attorneys?
There are attorneys, there's defense advisors, and then if there's a compliance issue or violation, they are entitled to perhaps separate counsel. But there are defense attorneys that sit on our treatment court teams. And I'm sorry, what was the first part of your question?
That's all right. And well, my second question is whether or not in acrimonious situations where a spouse comes in and doesn't want any part of this, how does the court handle that?
Are you talking about a spouse was maybe a victim or?
No, just separately. She doesn't want any, or he doesn't want any part of anything with the courts.
Yeah.
Just like that, yeah.
Oh, you're talking about for the family treatment court?
Yeah, sorry.
Well, so that would depend on if one of the parents was a respondent or if both of the parents were a respondent. So there's many abuse and neglect cases where maybe only one parent is a respondent. So if the other parent is a non-respondent, then they are not compelled to participate in services. If they are a respondent, they may be eligible for the family treatment court or they may have a separate case. But
thank you.
Yeah.
The committee will go at ease.
We are back on the record. I'm going to read in some cards here. Supporting the package, not wishing to speak, Nathan Triplett from the State Bar of Michigan. Supporting the bill, and already spoke, Kate Hootie from the Michigan Association of Treatment Court Professionals. Supporting the bills, not wishing to speak, Samantha Gibson from the Michigan Association of Counties. Supporting the bill, not wishing to speak, Alicia Moon representing SCAO. Opposing the bill, not wishing to speak, opposing 4523 and 4525, the Michigan Domestic and Sexual Violence Prevention and Treatment Board. And that is it for today. We hope to take these bills up at our next hearing to pass out. And seeing no absent members and no further business before the committee, we stand adjourned.